Everybody doing today? Happy Saturday, y'all. What's going on? I had to take a minute to read this. This was very interesting. So yesterday there was a filing in the case of Sarah Boone. Sarah Boone's number 8 attorney, Ms. Cashman, has exited the chat. I'm sure, as most of you may or may not already know, Sarah Boone has gone through 8 lawyers, and the judge filed a response basically to the motion to withdraw and Sarah Boone's 58-page letter. And basically, this is how it goes. Hold on a second. This is what it do. Ma'am got what she wanted. So I guess maybe she's gonna be happy now. I don't know. Hold on a second. Let me get my screens together. How's everybody doing? Y'all, we were up late last night. So if you missed the Nesto video, we did a reaction. We did a little bit of reading. We did a little bit of everything, and we did it in a little bit of time. That's the news from last night, is that we did it in a little bit of time, and the live is posted, and it was fun. We had a good time, and we weren't up all night, even though it may have felt like it, because it was like 1:30 or something when we finished up. But at the end of the day, I had a really good time, and I hope you guys enjoyed the reaction. It was 2 short videos anyway, so it was cool. Anyway, guys, I hope you guys are having a wonderful day. I wanted to go through this particular document because we've been talking about Sarah Boone here and there, and at the end of the day, it appears that her trial is going as scheduled, and the judge said there will be no disruptions, rescheduling, there will be nothing. Thank you. That was funny. Farrah, don't bother, hun. Wait till I'm done. Sorry, guys. Sorry, guys. We had a package delivery as per usual. Okay. Let's get into it, guys. So, it's like as soon as they start barking. How's everybody doing? Gangstars, Black Swan, God Created Black, Patty, what's good? How is everybody doing? Take a minute, hit the like button for me. If you're new here, welcome. Subscribe, and let's see what's going on here. Okay. This is the state of Florida, specifically Orange County. The cause came before. Hi, Coco Chanel. Girl, and whatever it was gonna be, it's gonna be even more, because people love a good pro se. I mean, look, it's not a foregone conclusion that she's gonna be pro se, but considering the fact that basically the judge says that her opportunity for a public defender has run out. She has gone through 8 public defenders, and she is basically chanced out. Now, based on what she may really want anyway, this is maybe what she had been looking for. So, look, she's whatever it is, she's going to have to deal with it, because this woman is quite difficult. She is the epitome of a Karen. If Karen is true, if Karen were a person, not just the notion of Karen, this is Karen right here. If you were look up Karen in any kind of, this is Karen. She's very strange, this woman. Anyway, but she is bright, and she seems to really be able to manipulate to get her way. So she's not just like your average dummy. And I'm sure any of you guys who've been watching this case know that. Even though she was a raging drunk, her and her boyfriend, unfortunately, Mr. George Torres, who passed away. This is the suitcase murder. And basically, they had been going back and forth as a couple. There had been some domestic violence. There were domestic issues. They were drinking considerably. Karen, Sarah Boone had been married previously. Her husband wasn't too far away. They split custody with a son. And one fateful evening, her and George were having an evening, and clearly she had built up resentment and hostility towards him. They got drunk, and basically her story is that they were playing a little game of hide and go seek. He decided to hide in a suitcase and let her tell it. They were playing, they were joking. She got tired and went upstairs and went to sleep, left him in the suitcase, even though she sat there and filmed on her cell phone him begging and pleading for her to open the suitcase. Let's get into it. The judge details he did a great job. Like, if you are new to this case, from the aspect of the attorney situation, he details it all out. It was funny because I did all this research like a week or two ago regarding the attorneys and their exits. He basically has detailed out the case of how she is chanced out on a public defender. So she has every right to have a lawyer and representation. She's going to have to pay for it. And ma'am has no money. Ma'am has no money. And so she does have support out here. She has people who write her. Um, and, by all accounts, people believe that maybe when she's writing these letters, she is communicating to her public. Okay, so let's get into it. Let me get this dog out of here. Just This cause came before, hopefully you guys can see. This cause came before the court on June 28th, 2024 on defense counsel Patricia A. Cashman Esquire, motion to withdraw as counsel filed June 11th, 2024, the motion. The court, having reviewed the motion, having reviewed the court file, having reviewed the audio transcripts from various hearings, have considered the position offered by Patricia Cashman Esquire, having considered the testimony offered by the defendant, Sarah Boone, and having considered the position offered by counsel for the state, hereby finds on March 23rd, 2020, by way of information, the defendant was charged with second-degree murder. On February 26th, the Office of the Public Defender, 9th Judicial Circuit, in and for Orange County, Florida, was appointed to represent the defendant. On March 9th, 2020, the public defender moved to withdraw due to defendant retaining private counsel. So she had a public defender March 9th, 2020. The public defender moved to withdraw due to the defendant retaining private counsel, Mauricio Padilla, Esquire, Padilla Law Group. On March 11, 2020, that certain order allowing withdrawal was entered. So this right here is going into the chain of events leading to the eight lawyers. So procedural history. So here we go. It's basically a timeline. So on March 11th, the order allowing withdrawal was entered, which withdrew the public defender from further representation of the defendant. April 18th, Padilla moved to withdraw due to irreconcilable differences arising between undersigned and the defendant that have made it impossible for undersigned to effectively represent his client. As always, it's difficult to convey all particulars to the court and at the same time maintain all duties to the client. This motion was served upon the defendant and the defendant confirmed receipt. See letter dated April 20th, 2020 and filed April 26th. We're going to go through all the letters. Remember, I told you that I pulled all of the letters and we will go through them one by one because he references everything. So this is like perfect timing because leading up to the trial starting soon. Okay. On April 29th, a hearing was held on Padilla's motion to withdraw. At the time of the hearing, Padilla had been representing defendant for 2 years. Defendant was present for the hearing and was sworn. The court advised Padilla that the court had received a letter from the defendant dated April 20th, April 26th, which seemingly objected to Padilla's withdrawal. She wanted to hold on to him. The court advised Padilla that the options were to not proceed on Padilla's motion to withdraw to provide the court more about the irreconcilable differences. Padilla requested an opportunity to amend the motion to address the irreconcilable differences. The court reserves ruling on Padilla's motion to withdraw gave Padilla until May 3rd, 2022 to prepare and file an amended motion with a hearing to be heard on the week of May 9th, 2022. The state advised of Padilla's diligence in preparation, and the court commended Padilla's work. Defendant testified to the lack of trust between herself and Padilla. On May 4th, Padilla filed an amended motion to withdraw, which supplemented the original grounds. Undersigned relationship with the defendant has become adversarial. The aforementioned adversarial relationship has interfered with the undersigned's counsel's ability to effectively represent his client, especially preparing for trial. Undersigned appreciates the court providing him an opportunity to amend the previously filed motion to withdraw. However, further researching the issue, undersigned is still under the beliefs that specifics and adversarial relationship may disclose information that may prejudice his client, and such will stand mute on the specifics. On May 6th, Padilla filed a second amended motion, which further supplemented the original grounds. Undersigned relationship with the defendant has deteriorated to the point where undersigned counsel can no longer give effective aid in a fair representation of Ms. Boone's defense. The motion is in compliance with Florida Judicial Administration 2.505 and Rule 4-1.16b. Rules regulating the Florida bar are present, and whether the attorney-client relationship has deteriorated to the point where counsel no longer can give effective aid in a fair presentation of a defense. So you see, even there, it really illustrates like a lawyer can't just like walk off the job. Like you have to have cause, you have to back it up. Like you can't really just when you accept a client, I mean, it's clearly serious because you can't just walk away. Let's put it that way. You can be separated from that person eventually, but it's going to be well documented, considered, and approved. Okay. On May 10th, let's go. Let me make this a little bigger. On May 10th, the hearing was held on Padilla's second amended motion to withdraw. Defendant was present for the hearing and was sworn. Padilla advised the court that he had no further choice to file this motion due to ethical concerns. So on top of adversarial relationships, now it's an ethical concern. Defendant confirmed that she wanted to terminate Padilla as attorney. The state expressed concern of the strategy to allow the defense attorney after the attorney to represent. The state expressed concern of a strategy to allow defense attorney after attorney to represent defendant. The court advised the defendant of the state's concern regarding the strategy of defendant being unhappy with every attorney and advised the defendant about the dangers of self-representation. The court appointed the public defender. So this is attorney number 3. So here we go. Attorney number 3. On June 6th, 2022, the public defender moved to withdraw due to conflict. Okay. So a month, not even a whole month. The public defender's like, yeah, nah, I'm good. Okay. June 7th, The certain order allowing the public defender to withdraw was entered, with which withdrew the public defender from further representation of the defendant and appointed the Office of Criminal Conflict and Civil Regional Counsel attorney number 4. That was on the 7th, right? June 10th, 3 days later, RCC, the regional, what was it? The Office of Criminal Conflict and Civil Regional Counsel moved to withdraw due to a conflict. 3 days later, they were like, I'm done. On June 22nd, 2022, that certain order allowing the Office of the Criminal Conflict and Civil Regional Counsel withdraw was entered, which withdrew RCC from further representation of the defendant and appointed Mark Consalo, attorney number 5. Okay. On July 8th, 2022, the Consalo moved to withdraw due to a conflict. On July 11th, that certain withdraw order was entered, which withdrew Consalo from further representation of the defendant and appointed Frank Bankowitz, attorney number 6. July 12th, 2022, Bankowitz in open court requested to continue due to his recent appointment, and same was granted. Therefore, so in fairness to her, I think there was one, and I have to pull my notes on it. There was one lawyer who had represented George Torres, and then there was another person who's a witness in the case that another attorney, another one of the public defenders. So when they said conflict, some of it's Sarah Boone, but some of it's just also her circle of people, because her boyfriend had been in some legal trouble, and one of the public defenders, turns out, had already represented, so that would have been a conflict. And then furthermore, there was a witness, somebody who was coming to testify to what I don't know, but already had a relationship with that person. So due to those two attorneys did withdraw for those reasons. So in fairness to her, even though she's on attorney number 8, 2 did withdraw due to prior clients, and I guess becoming engaged with Sarah Boone. Then that information, then they realized that there was a conflict there. Okay. But you would have thought that when the cases were assigned that someone would have done some due diligence as far as, but I don't know. I don't know. Anyway, I don't know how they make all of those connections, but once the connection was made, the attorney withdrew. On July 12th, Bankowitz in open court. So we read that one. On October 25th, the court held a pretrial conference and addressed the court's understanding that a continuance was being sought, and the court's judicial assistant was to reach out to the parties to confirm if the continuance was being sought. On October 27th, Bankowitz filed defendant's motion to continue. October 28th, the court entered that certain amended order on defendant's stipulated motion to continue, which set the pretrial conference for January 17th, 2023 at 9 a.m. During the trial period beginning January 30th, 2023. On November 22nd, 2022, the court set a status hearing Tuesday, December 20th at 10:45 a.m. On December 19th, Bankowitz moved to withdraw due to irreconcilable difference, which have arisen between the undersigned, his client, and his family. The undersigned will be unable to effectively and properly continue representing the defendant. So basically, it was also said that Sarah calls constantly. She's calling constantly on his personal cell phone, calling collect, trying to call and discuss the case as if she's his only client. So it's irreconcilable differences between the client and his family. So that's probably due to just being very, very high maintenance, and him not being able to give her what she wants, which is a lot of time, and she's not his only client. On December 20th, the status hearing was held. Bankowitz did not appear due to a car accident, and the court reset the hearing for December 22nd at 11 a.m. On December 22nd, the reset status hearing was held. Bankowitz appeared virtually, and due to technological issues, Bankowitz was unable to hear the court. The court reset the hearing for the 27th. The 27th, the hearing was held. Bankowitz's motion to withdraw. The defendant was present for the hearing and was sworn. The court advised the defendant that the court had received letters from the defendant dated October 3rd, October 7th, November 3rd, dated November 3rd, filed November 7th, and dated the 5th and filed on the 14th. The court conducted a Nelson hearing, and the defendant was not seeking to remove Bankowitz. Bankowitz advised the court of thousands of pages of discovery that he had reviewed and organized, and his contact and professional use of and collaboration with expert witnesses, including experts that Padilla, attorney 2, utilized. Bankowitz advised that the court of the defendant's attempt to call Bankowitz at a rate of 5 to 10 times a day. Bankowitz further advised of his efforts to balance the demands of other clients with the defendant's expectations for communication. In response, the defendants reposted that Bankowitz's representations were untruths, raised Bankowitz's prior public reprimands, and lack of communication. So him not answering the phone, she brings up the fact that he had had issues with the state regarding him not being responsive and lack of communication. So she found some tea, or she found some receipts to basically make it like not a her issue, to either make it a we issue. Okay, yes, I'm calling, but also he's got a history. So she was able to basically find a reason to not completely make it her fault. This woman is a mess, okay? Which I don't blame her for finding the information and basically getting it, finding something to make her not look as bad. But at the end of the day, sis is still looking bad. No matter what she does, it's still bad. In response, the defendants reposted that Bankowitz's representations were untrue. So basically she's untruths. Basically she's saying he's lying, and she found other public reprimands for lack of communication. So she came with her own receipts. Basically like, you're going to make me look bad, I'm going to make you look bad too. Alleged Bankowitz's actions in this case rose to a similar level. So she's basically accusing him of what he'd been reprimanded of before, then sought to remove Bankowitz. The court pointed out defendants' inconsistent statements within minutes of them being made, and addressed concerns over defendant's motivation, especially when there is something defendant disagreed with. The court specifically advised defendant that she is not entitled to an endless line of court-appointed lawyers until you find one that you personally prefer. The court also explained, hopefully, even though this is a whole different state, you are not entitled to an endless supply of public defenders until you find one you personally prefer, to maybe somebody who's using public defenders in Georgia. Okay? You're not entitled to keep swapping out. Okay? The court also explained the circumstances where defendant could represent herself. So it was also introduced at that time. Yeah, you could actually represent yourself if you want to. Also, there's the other option of, and you can pay for it yourself, right? So you can deal with what you have, which is what the state is providing for free. Represent yourself, and or pay. Okay? Ultimately, defendant did not request to remove Bankowitz. The court denied Bankowitz's motion to withdraw and directed Bankowitz to have a conference with the defendant prior to the pretrial conference previously set for January 17th, 2023. The case was continued several times due to Bankowitz's attempt to retain an expert through JAC and JAC's response to same. Footnote 6, which was the ex parte motion for appointment of a defense forensic psychologist and a request for a sealed order e-filed 717 and Justice Administration Commission's ex parte response to motion for appointment of defense forensic psychologist. So there's some footnotes here to the bottom. During this time period, the court had received several letters from the defendant dated January 10th and filed January 17th. The letter dated March 22nd, 23 and filed April 14th. The letter dated April 6th, filed April 14th. The letter dated May 15th, filed May 18th. The letter dated June 29th, filed July 21. And the letter dated April 2nd, filed August 7th. Now, this lady writes a lot of letters, as we've discussed, right? On August 22nd, Bankowitz again moved to withdraw due to irreconcilable differences arising between the undersigned and the defendant that have made it impossible for the undersigned to effectively represent this client. As always, it is difficult to convey all particulars to the court and at the same time maintain the duties to the client. The defendant will not be satisfied with any attorney unless said attorney does not have a caseload and can dedicate his or her time solely to Ms. Boone's case. The best possible avenue is to have the defendant represent herself, as no attorney can satisfy her. Okay? On September 8th, 2023, a hearing was held on Bankowitz's motion to withdraw. Defendant was present for the hearing and was sworn. Bankowitz addressed the defendant's derogatory statements, i.e., girl, she called him a dud and a buffoon, okay, and berating behavior. Okay, so not only was derogatory statements such as calling him a dud and a buffoon, but she also spoke to him he said berating behavior. The court advised defendant that the court had received letters from the defendant, a letter dated August 26, 23 and filed September 7th, 23, and a letter dated August 30th, filed September 7th, after the court's colloquy of defendant and her acquiescence to Bankowitz's withdrawal. So basically, she agreed. Colloquy, I need to look up that word. I don't know what that word means. Colloquy, let's see. Colloquy is the gathering for discussion of theological questions. Oh, a conversation. Okay. So let's go back to after the court's colloquy, aka conversation of defendant and her acquiescence to Bankowitz's withdrawal. Acquiescence is basically just to kind of agree to agree. Maybe not necessarily that you do agree, but you're just agreeing to you've said okay. The court granted Bankowitz's motion to withdraw and appointed Winston Hobson and attorney number 7. Thereafter, the court set a status conference for October 30th, 2023 at 10 a.m. and set pretrial conference for November 28th at 9 a.m. After setting these dates, the court pointed out the deterioration of the working relationship between the defendant and Bankowitz. The court further cautioned that if this becomes a problem on another court-appointed attorney, just one second, guys. Okay, guys, sorry. Busy Saturday. After setting these dates, the court pointed out the deterioration of the working relationship between the defendant and Bankowitz. The court further cautioned that if this becomes a problem on another court appointed attorney, it's going to look more closely at the alleged disputes, at what the alleged disputes are. The court further advised that there are certain decisions the attorney gets to make and certain decisions that the defendant gets to make, i.e., go to trial and or testify. The court cautioned as to the defendant's unrealistic expectations regarding the court appointed counsel and reminded the defendant that of her right to retain private counsel. So basically, like, you can do what you want, but at the end of the day, you can also pay for it. So um they had to remind her that. On October 30th, 2023, the status conference was held. Hobson advised as to his conversation with the defendant and setting a status of January 2024. Therefore, the court set a pretrial conference status as the readiness for trial January 16th, 2024 at 9 a.m. and trial during the trial period. Enter Hobson. Let's see. So basically, let's see, pretrial conference status as to the readiness for the trial. On January 12th, Hobson filed a motion to continue waiver of presence and requested a 3 docket continuance. On January 16th, the court addressed Hobson's motion for continue, granted same, and set pretrial for May 2024, 9 a.m. The trial during the period beginning May 13th. On February 1st, Hobson moved to withdraw due to irreconcilable differences, including but not limited to ethical considerations. On February 9th, 2024, a hearing was held on Hobson's motion to withdraw. Hobson addressed a number of issues as for the basis of withdrawing, including disagreements on legal strategy, on what can and cannot be done, a lack of resources, the defendant's demands to make difficult to work with, including defendants taking non-viable legal positions and being unreasonable as a key to substantive defense. Hobson advised that the retained and undisclosed expert is not keeping with what defendant has in mind. The court advised defendant that the court had received a letter from defendant, a letter dated January 19th, 2024, and the court outlined the overriding claims for withdrawal by Padilla, Bankowitz, Hobson, and adversarial relationships, lack of satisfaction, and the inability to meet the defendant's desires. The court found that all the defendant's relationships with all court appointed counsel have deteriorated such that the defendant and the court appointed counsel cannot work together. The court advised defendant that although defendant has the right to court appointed counsel, the right is not unlimited. The court twice advised the defendant that defendant may not be provided another court appointed attorney and the defendant would have to represent herself if circumstances similar to Hobson's motion to withdraw occur. The court further advised defendant about the dangers of self-representation due to defendant's lack of legal training and knowledge. The defendant, however, stated that she did not understand that she may not be provided another court-appointed attorney. The court granted Hobson's motion to withdraw and appointed Patricia A. Cashman and attorney number 8. The court is aware of Cashman's extensive experience representing criminal defendants as both a assistant public defender and in private practice, including representing defendants accused of murder, and is widely known to be able and willing to deal and manage difficult clients. The court set a status hearing for April 12th. On April 12th, the status hearing was held. Cashman advised that to the dispositions that had been set, the hiring of an expert, and the request for future status dates and to address a trial date. The court set the status hearing for June 7th, 2024. June 7th was earlier this month. On June 7th, the status hearing was held. Cashman addressed her dates of availability for trial. The defendant was present for the hearing and was sworn. Thereafter, the defendant advised the court to walking out of multiple meetings with Cashman, which was confirmed by Cashman utilizing a pretend judge to oversee the defendant, and Cashman launching multiple attacks on Cashman's professionalism and providing the court with letters dated June 4th, 2024 and June 7th, and both of which were filed on June 21st, 2024. Cashman advised to her efforts and time spent on the case so far 20 hours. Cashman addressed disagreements on legal strategy, including defendants attached importance to issues that may not legally be important, and riposte defendants accused Cashman of lies and half truths. On June 11th, 2024, Cashman moved to withdraw under Florida's rule regulating the Florida Bar 4-1.7, substantial risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client. So basically, almost just again the unrealistic expectations, but she used the bar that basically stating that this particular client is requiring so much that it's going to be detrimental to my other clients. That's what I interpret that to mean. The irreconcilable differences, including but not limited to ethical considerations, have arisen such that counsel can no longer provide representation. On June 28th, which was yesterday, a hearing was held on Cashman's motion to withdraw. Cashman relied on Florida's rule regulating the Florida Bar and Schwab versus State as the basis for her withdrawal. At no time has defendant refused to accept the services of any of her 7 attorneys. Both the United States and Florida constitutions guarantee an indigent criminal defendant the right to assistance of appointed counsel. The counsel clause of Florida Constitution under Article 1, Section 16 recognizes the right of counsel as well as self-representation in all criminal prosecutions. The defendant in a criminal case can forfeit a right to court-appointed counsel. Forfeiture is an extreme measure that follows from the defendant's abuse or manipulation of and result in the defendant being required to represent himself, even though he has not waived counsel and still wants legal representation. And the laws are cited, right? Forfeiture is a judicial response that adapts the course of the legal proceeding to the defendant's choice to engage in misconduct that undermines the legitimate exercise of the right to counsel. So they're basically calling her on her bullshit at this point. As set forth above, defendants' recalcitrance to the attorneys who were not conflicted out, Padilla, Bankowitz, Hobson, and Cashman, antagonism, hostility, and attacks on professionalism of Padilla, notably over a year after the fact, see footnote 9, of Bankowitz and of Cashman, and personal attacks on Padilla, Bankowitz, Cashman. Each of these attorneys were required to withdraw. It has become apparent to the court that the defendant will not permit herself to be represented by anyone. Additionally, withdrawal of 8 different attorneys, 7 of which were court appointed, leads to the determination that the defendant has forfeited his right to counsel. See Watson versus State, receded from the grounds by Waller versus State, Under Florida law, the facts at the bar amount to binding forfeiture and the right to counsel. Like they basically they put this whole thing. So she cannot, basically, she is not going to be able to come back and appeal based on lack of legal representation when she has been offered more representation than most. And also, it has been well documented that she has made it difficult for the professionals to come in to actually help her. And it's also potentially being seen as a strategy to manipulate and delay the inevitable, which is the fact that, sis, you got to go to trial and the trial is coming. Okay. Um, as the court finds the defendant has forfeited the right to court appointed counsel, under Florida law, there is no obligation to conduct a Feretta hearing or to otherwise warn the defendant of the dangers of proceeding pro se. And the reason for that is because the judge has already warned her on 2 occasions she could forfeit her right to counsel if she continued to behave in this manner, and that she would have to proceed pro se if she'd run out of opportunity to have court appointed counsel. Okay, so she's been appointed 7 lawyers. She had 1 paid lawyer, and every lawyer has withdrawn. The court can find a waiver, excuse me. The court can find a waiver to conduct to the right to counsel. Waiver by conduct requires that the defendant be warned about consequences of his conduct, including the risk of proceeding pro se, which the judge has done. On February 9th, 2024, the defendant was twice advised that another court appointed attorney may or may not be provided. On May 10th, the defendant was advised of the dangers of self-representation. On May 9th, the defendant was advised about the dangers of self-representation. As of February 9th, the instant case has been continued. The instant case has been continued 16 times. As of June 26th, the case has been pending 4 years, 3 months, and 5 days from the date of the filing of information on March 23rd, 2020. Okay, just to put it into perspective. Actions speak louder than words. Although defendant's words seemingly reveal a desire to go to trial, however, as set forth herein, her actions and inability to work with court-appointed counsel are repeated over and over, allowing defendant to her 8th court-appointed attorney, her 9th attorney overall, will only serve as a delay for the case further and encourage the defendant to persist in efforts to prevent the resolution of the case on its merits, the concept of which was first brought defendant's attention May 10th, 2022. The defendant explained that Bankiewicz and Hobson, 2 court-appointed attorneys, failed to meet and communicate when defendant is provided court-appointed counsel who will meet and communicate. Cashman. The ways and means of meeting and communicating are unacceptable to the defendant. Under Florida law, the facts at bar amount to binding waiver of the right to counsel. See Jackson versus State. Orders and adjudes. Cashman's motion to withdraw as counsel filed June 11th, 2024 is granted in big letters, right? All caps. As a condition of Cashman's withdrawal, Cashman shall provide the court an order for cost to obtain transcripts and disposition for the 2 witnesses Cashman disposed. Upon completion of the transcripts and disposition, the disposition transcripts shall be sent directly to the defendant, Sarah Boone, by Cashman and the Orange County Jail. Thereafter, Cashman shall file a notice with the court reflecting that all disposition transcripts were provided to the defendant, Sarah Boone, and such notice shall include the date sent and the address of defendant, Sarah Boone. Defendant Sarah Boone has forfeited her right and to court-appointed counsel. Alternatively, defendant Sarah Boone has through waived her conduct through her conduct waived by her right to court appointed counsel. The trial management conference shall remain specifically set for Tuesday, September 24th at 1:30 p.m. So basically, even though this whole thing has happened, they are not changing the dates. They're proceeding as scheduled. The case shall remain specially set for trial for the 2-week trial period beginning October 7th, 2024, and will not be continued for any reason except by extraordinarily good cause, and such extraordinarily good cause shall not include retention of counsel by the defendant. So even if she were to get a lawyer, retain a lawyer on her own, it's not going to delay anything. They're just going to have to get up to speed, and it's going to be, oh well. Any and all pretrial motions in this case must be filed no later than the close of business Monday, July 22nd. Any and all pretrial motions must. So she's on the job now. All that letter writing she's been doing, she's going to have to do everything herself by July 22nd. She's going to need to figure out what needs to be what needs to be filed, what needs to be answered, what needs to be put in, what provisions. She's going to have to get some sort of legal advice maybe, but I don't know if that's even something that's available to her. But she's got a second-degree murder case, and it's Florida. Um, so certificate of service, I hereby certify that the foregoing was filed with the clerk on the 28th day of June, 2024 by using the Florida court's e-filing portal system. Accordingly, a copy of the foregoing is being served on this day to all attorneys, interested parties identified in the e-portal service list via transmission of notices and electronic filing generated by the e-portal system. I hereby certify that a true and correct copy of the foregoing has been furnished to each of said parties by hand delivery on this day, the 28th of June, which was yesterday. State of Florida, State Attorney of the 9th Judicial District. And that's it. That's all. And that was signed Circuit Judge Michael Kranick. Okay. We made it through it. Can you believe it? I've never had so many interruptions, guys. Thanks for sticking with me on that. Interesting, right? That you can run out. You're chanced out. Sis chanced out, and she ran through every single chance and opportunity to be able to have a court-appointed lawyer. Let's just be honest. Clearly, according to the court and the court's observation, she doesn't want one. And if she wants one, her actions say differently, right? So that's where we're at. And we are going to go back in time, and we will rewind the timeline and get into some of her letters starting from the beginning, because she's had a lot of complaining, and the judge did an excellent job with this timeline and basically dropping all of the receipts and footnotes and everything. I'll make this available. I'll put this as a free as a download. You don't have to have membership. You can do the free membership on Patreon if you want to read this for yourself. I'll post it as a post. You just have to register with the Patreon. Okay. So I'll have this posted if you want to read this for yourself. And as we read the letters, I'll post them to Patreon as well. They are available if you want to, like someone said, do the research yourself, and go to the Orange County Clerk of Courts and go ahead and go through those 4 years. Was it 4 years? However many months and all of the time, and get them all yourself. But there's a lot of letters. Anyway, 4 years, 3 months, and 5 days. Well, it's probably 6 days now. So yeah, well, 7. That was on June 26th. So this is 3 days later. So 8 days actually. Um, will she be provided shadow counsel? I don't know. She's gonna have to request that. And they said no more public defenders. So so everything what I said was basically what was in the document. Shadow counsel, I'm assuming she's gonna have to pay for that. No more public defenders. So shadow counsel will be what? Would that be a public defender who's gonna just sit there behind? I don't know. I mean, she has created a situation where the state is no longer helping her. Like, you are on some state charges. The state has afforded you um, legal counsel, and she has gone through so many times that she is no longer eligible for that benefit and entitlement anymore. She's no longer entitled to the entitlement. She has chanced out. And also, let's think about it too. That's taking away from other people who need representation, who really want a lawyer. And it's crazy that these lawyers opt out so quickly. It's like, damn. But at the end of the day, it's been very consistent that she's really someone who's difficult to work with. So difficult that these professionals who are skilled in working with these folks can't even work with her. The poor victim's family, absolutely, that it's just delay after delay after delay after delay. And I think this woman will have her day in court, but at the end of the day, I don't think that she is going to be able to evade prosecution much longer. Hey, Tammy. Hey, boo. I see you. I just realized I was like not clicking on stuff. Um, she's not going to be able to prolong this out. So, it's coming. It's coming. So she can delay it all she wants, but at the end of the day, her day is coming. So anyway, guys, I'm not going to hold y'all much longer. Thank you guys for kind of sticking out, sticking through the crazy interruptions in the middle of this broadcast, but life was lifing. It's a Saturday. Anyway, we will get together again and we'll do her first letter, go through as many as we can. But the trial is coming. It's coming, it's coming, it's coming. And I think she has done a really good job of earning herself a spot on court TV and Law and Crime. This is definitely going to be one of those that's going to be broadcast live. I'm sure. I'm sure of it. So this is going to be interesting. So I'm ready. Okay. Anyway, guys, have a wonderful Saturday. I'll be back. I know we've got some texts to look at from Nesto and all of that. So if you're new here, welcome. Make sure to subscribe to this channel, have your notifications set. And next time I go live, post another video, you will be notified. Everybody have a wonderful day. And I'll see you next time I go live and post another video. Take care. Bye.